So, welcome back to the PI show. Our last segment is Viv's mailbag, and it's got a real momentum going. So, Viv, there's quite a few questions for this week.
Thanks to all of you for writing into the pishow.com. We've got a question here from Jack today. He says, "Hi guys, love your show. It's really interesting and informative. Thanks, Jack." He writes, "I sustained an injury to my lower back in March 2008. I'm thinking of starting a civil action against my employer, so a serious injury. Is it advisable to apply for an impairment benefit first, as my orthosurgeon has assessed my injury at 5% damage according to the AMA, that's the Australian Medical Association guide? Please advise. Thanks, Jack."
Jack, you've got a choice. You can either put in for an impairment straight away. You've got to wait 18 months from date of accident to put in an impairment. But the alternative is to go straight for a common law claim. So it's a matter of circumstances. With a common law claim, you've got to establish, firstly, you've got a serious injury, and secondly, the employer or some third party's been negligent.
Yep.
They're the two things. Without that, there's no civil claim. So you've got to look at both those factors,
Harry,
before making a decision.
because it's been more than 18 months, my preference would be to lodge common law, but it depends on his financial circumstances. Plus the other thing that would be pretty important would be how strong your case is on negligence, which is what Harry touched upon.
Yeah, no, he doesn't mention negligence at all.
No.
So he's got to have a civil case, has to have negligence in Victoria.
Okay.
And a 5% impairment.
What does that actually mean?
Well,
to
that's
the ordinary viewer?
again
qualifies
an American
him
guide, and there's different tables, and he falls under a 5% table, and that will give him compensation of about 11,000 as a lump sum.
If he's
So
not
that's
happy-
for pain and suffering,
Right.
loss of enjoyment of life.
Okay.
If he's not happy with that, Harry, he can always go to a medical panel, and they might give him more. You just don't know.
Yeah, but it's a no-fault benefit.
Right. Ultimately, you probably should consult with a lawyer, though, do you
I
think?
consult with a
He
lawyer.
should get a lawyer's opinion.
Great. I have another question. This is from Anton, whose wife has actually written on his behalf because his English isn't very good. But he writes, when he was 42, he sustained inoperable damage to his L1S5, so that's a back injury. He has both certificates and will be suing his employer. He was earning a high income, working in the building industry, and would like to know where he can get an independent estimation of what his claim is worth, as well as what he should include with his claim. He further goes on to say that his insurer has denied any physio expenses. He doesn't believe it's actually helping him. He says that he's worked in the building industry since he was 14 and doesn't really have any other skills, so he can't really read or write. He further goes on to say he's been given inconsistent information regarding the age until which future loss of earnings will be calculated, given that he's a building industry worker. So the question he's actually asking, though, is can he get access to previous payouts for his back injury?
Viv, he's raised a lot of issues.
It's quite
He
comprehensive.
definitely needs a lawyer. But of significance, apart from his Accident Compensation Act entitlements, which is no fault benefits and also common law, he's got some very valuable rights. Being a building worker that came in some time ago, at the time when common law was abolished.
Right.
And that's INCO-linked benefits, depending on who he works for.
What does INCO-link again mean to the viewers?
INCO-link was introduced a long time ago when common law was abolished, and they struck an agreement, the union and the larger employers in the building industry, where they took out a policy of insurance that picked up loss of income and also
a lump
trauma.
sum.
It was a trauma cover, and in most instances, if you got dependents, that trauma cover could be $250,000 payout.
Right, so it's quite
So it's
considerable.
quite substantial. So it sounds to me that Anton's got some pretty substantial benefits. And the question about payout, Harry, is interesting because it depends on how long you'd stay in the industry, because when you're in the building industry, your body generally wears out. So there's big issues about do they work until 50, 55, 60, 65 or even beyond that date.
Okay.
So it really depends on the individual. And
It's a matter of evidence
Okay.
and whether he's had any pre-existing problems, and the likelihood is of what would have happened to him but for the injury.
Okay.
So would he have worked till 65 or would he have retired earlier? And comparable verdicts, you can look up previous judgments about people who are 42 years old who've had back injuries, who have received compensation. they're available in the public domain, but every case is different. The beauty of common law is every decision is tailored to that particular person. So there's no rule of thumb, a 42-year-old building worker with a badge back has to get $200,000 as pain and suffering. Depends on what effect that injury has on him and what the medicals say and what he says about his injury, and then the judge has to assess it.
So the L1S5 injury, does that...
It's a damaged
Well,
back.
it's a
Low
lowest
back.
disc in your lumbar spine,
Okay.
Yeah.
and it can be quite significant.
And physiotherapy expenses which aren't being paid, the law, in my view, is very cruel. The law says if your physio is not improving your condition, then work cover may not have to pay.
Right.
Now, if it's
And
maintaining...
that's what they're arguing.
Yeah,
so-
if it's maintaining your condition, there's an argument that work cover don't have to pay for simple maintenance. If it
you-
deteriorates in the absence of treatment, then there's an argument that he should take it to conciliation, and then ultimately a judge would decide, if it can't be resolved, whether the physiotherapy is what's called a reasonable medical expense.
Well, Harry, if he was working, the prospects of him getting physio for maintenance is higher because it's keeping him on the job.
But it's not at the moment.
No.
But the law, in my opinion, is not helpful
in
to
his
workers.
favour, yeah.
Not helpful.
So in summary, how would you advise Anton, given his
He
experience?
Well, look,
might have
he's-
substantial benefits. I'd really consult a lawyer.
He's got, we think he's probably got common law benefits, and he's got things arising out of his superannuation fund, and the other policy of insurance is Incolink for building workers.
And also superannuation, Harry.
Yeah, superannuation, which
CBUS.
is under
And that's
C-
quite substantial
CBUS
these
as
days
well. So they're independent of his rights under the Accident Compensation Act. So the building workers in Victoria are in an unusual position in that they've got relatively generous benefits outside the Accident Compensation Act. They work hard and they've fought hard for their rights, and
Harry,
they deserve every penny they get.
Unusual but favourable. That's the beauty of it.
Yeah.
So only 2 questions this week. Sorry, guys.
Keep sending the questions in. If you're in doubt, consult a lawyer. You should contact us through our website,
I think that's
and
important.
we read all the questions, and we seem to be getting a lot. So
It's inundated, so thank
Viv,
you.
since you've come on board, I think we can get through a lot more.
yeah, no,
We try.
it's very helpful, and they're fascinating to assess and discuss. Thanks for watching, and see you next week.
Thanks, guys.
Thanks.
Thanks.